Good morning to all of you. This video is for the law of torts students. Friends, in the last class we discussed the strict liability and I have given in detail the facts of Rylands versus Fletcher 1868 case. So, in this strict liability, there is a leverage. So, if you are able to prove the case in any of the 5 or 6 sections which I am going to deal with, then definitely I am sure you may not be liable under the so-called strict liability also. Normally strict liability means even though there is no negligence on your part, definitely you have to pay compensation because damage has taken place. But if you are able to place your case in any of the defenses like plaintiffs won't default, plaintiff the wrongdoer, previously we tell you plaintiffs won't default, then consent of the plaintiff, then act of God, act of third party, and statutory authority. 5 years given. Anyway, so if you are able to prove these things, definitely you can escape from the so-called strict liability. Please remember, as advocates, so these called exceptions are necessary. Why? Whenever you are, so don't expect so many very good people come to you. Definitely the people who violate the law, the people who commit the offense, or the people who are the tortfeasors, they only come to you. So then when you take up the case, definitely you have to find out whether this case fits in any of the defenses. Now we'll discuss the defenses one by one. First case, plaintiffs won't default. So plaintiff, the wrongdoer. So if the plaintiff suffers damage by his own action or by his own intrusion into defendant's property, then he cannot complain that a tort has been committed. Very good example is Ponting versus Noakes of 1849. So actually what happened is Ponting's horse, she jumped the fence into the defendant, that is Noakes' garden, and it has nibbled the leaves of a poisonous tree, as a result of which later the horse died. Now Ponting brought a case against Noakes for defense, for negligence, but Noakes was able to prove that he has fenced the garden properly and he has made a board, he has fixed a board in front of the garden also, that he was actually growing some herbal medicines, maybe poisonous. So like that he was able to prove that plaintiff, that is the horse owner, Ponting, he has not taken care of the horse properly. He himself has done a wrong thing because the horse jumped the fencing and he has gone outside. So since he is able to prove that the complainant or the plaintiff is the wrongdoer, so, and if the horse did not intrude into the defendant's land, it would not have nibbled the leaves and died. So no compensation. So they called the exception, that is defense has been accepted. Second one, consent of the plaintiff. Sometimes this is, we called it as previously voluntary non-fit injuria. So very good case, Constraints versus Taylor, 1871. So here what happened is the plaintiff, that is constraint, he has taken the ground floor or lower floor of an apartment. Actually the defendant is a tailor, he was residing in the upper floor. So at the time of leasing the ground floor for rent, the defendant clearly told him that there is some leakage of water and it may cause some problem, you should be careful. But this man, because the rent is low, he has agreed and ultimately, so he has agreed and ultimately he has spread some of all his belongings on the floor. He did not have the so-called iron safe or cupboards, thing like that. So on the fateful day, the water from the overhead tank leaked. Ultimately, it has come to the ground floor. That is the ground floor, and ultimately the properties which were kept on the floor of the plaintiff have been damaged. Now whom to blame? He himself has consented because of the lower amount of rent. So no, this exception, this defense has been accepted. Water stored for benefit of both plaintiff. Yeah, this water is only not only for the plaintiff or not only for both of them. So as such, defendant is not held liable. Right? Act of third party. This is also more important. Act of third party, because No doubt, you know, you want to do something, but some stranger, third party will come and obstruct the same. Then what is that you can do? An example I want to give you is, suppose if the water supply for Ongole Municipal Corporation is being drawn from Vellampalli, then when the municipal people have released the valve to come to Ongole. So, but en route, the pipe was breached and the water has been diverted to one agriculturist. As such, the water did not come to Ongole. So, if the municipal corporation is able to prove that we did our best, we have released the water, but in the meantime, the stranger, a third party, has diverted the water. Yes, that exception, that is a defense, very good defense. So there is a case law. Box versus Jubb, 1879. So this is also just like a Rylands versus Fletcher case. So both Box and Jubb, they have got reservoirs. Above this, a third party, third person, he has got a reservoir. Actually, the third party has opened the reservoir, has breached the reservoir, which came through the Jubb's reservoir, ultimately spoiled the Box, plaintiff Box reservoir. Ultimately, even though Box failed the case, since Jubb was able to prove that the water came from the third party, so not so this exception or defense is also accepted, right? Actually, these things are important. Act of God, you know, that is Nicholas versus Marshland, artificial lakes. So actually, this man, the Nicholas has got 4 bridges. Marshland, he has constructed some artificial lakes and actually filled them with water. But due to the torrential rain or continuous rain or downpour of rain, so which one could not foresee totally. So the force is so that we can't expect. So due to that act of God, the lakes inundated or the lakes were breached, and actually the 4 bridges belonging to the plaintiff, they have been damaged, and ultimately the court held that it is due to an act of God which we cannot foresee. So it is a force which you cannot expect and you cannot foresee. Therefore, the defendant was not liable as it is an act of God. See, very good judgment. And ultimately, statutory authority. I will give you both examples. Statutory authority. Normally, at times, things will be happening. Here, a negative example is most famous case, please remember. Kamtam Nagireddy versus State of AP, 1982. So Nagireddy garu, he planted some fruit-bearing trees, 285 number, by the side of the so-called Nagarjuna Sagar Dam. So at that time, normally during the year 1999 or 1970, the dam was on construction. So many branch canals were there. Actually, his land is located by the side of one branch canal. So during the trial run process, the authorities, irrigation authorities, they have released the water. So the water actually, since it was given at a heavy velocity, they have entered, or the water has entered the fields of Kamtam Nagireddy, and due to overflow of water, actually the fruit, the plants, actually they have taken excess of water. Ultimately, they withered away or they died. Now he filed a case of negligence on the part of irrigation authority, that is the state, stating that they have not riveted the line, they have not cemented the canal, all these things. But court did not agree. It happened by the side of branch canal number 10. So how could, only one commenter, how could people live in India if there is no water? Water is necessary for drinking, for agricultural purpose. So at times during the trial process, some damage may happen. You cannot claim compensation for the same. Okay. Now another case. This is Green versus Chelsea Waterworks, 1894. So Chelsea Waterworks, they released a pipe. Actually, there should be some pressure, that is a reasonable pressure. The waterworks released the pressure. So due to high pressure, some actually the water damaged, the water actually forced they came out with a heavy force and they caused some damage. But it was held that as per statutory authority, yes, they have to maintain that pressure, otherwise that water will not flow. So sometimes damage may happen. So you cannot fix the state for this. Right. Likewise, sometimes electricity people also, even though it is a quasi corporation, they also state that statutory authority, but it will not be accepted. Here it is a typical case where you can take it, you can put the defense as an act of stranger or act of statutory authority, but it is a negative example. Please know this case also. This is Madhya Pradesh State Electricity Board versus Shail Kumar 2002. Right. Here what happened is, on the night of 23/8/1977, the deceased Mr. Joginder Singh, aged about 37 years, was riding his motorcycle and he was going from his factory to his home. There was heavy rain. Actually, due to the heavy rains, there was some snapping of the live wire. Live wire padipoyi water lo unnadi. Wire in water. Live wire, it was cut due to heavy gales. Then due to heavy rains, it was falling across the road in the water. Right? So the snapped live electric wire, he did not see it due to the water lagging. Ultimately, so he hit the wire actually while traveling and he was injured. And later in the hospital he died. Then the electricity board stated that it is an act of stranger, not accepted. So somebody might have missed. No, it's a snapped wire. That means due to heavy gales, it fell down. So actually, the electric people, they want to say that it is due to the act of mischievous act of a person. Evado cut chese dani valla padindana. Will they accept? No. That too. Statutory authority. So idu kuda better, but court did not agree. Are baba, while maintaining the electric lines, you should be more careful. When there is, అందుకని మీరు చూడండి, కరెంట్ పోతే ఇమీడియట్గా కరెంట్ కాదు ఏమంటారు, ఈ వర్షాలు లేకుంటే వస్తే ఇమీడియట్లీ దే విల్ స్విచ్ ఆఫ్ ది ఎలక్ట్రిసిటీ. యూ షుడ్ హ్యావ్ టేకెన్. లేదు, వైర్ పోయిన తర్వాత ఇమీడియట్లీ యువర్ పీపుల్ షుడ్ గో అండ్ అట్లీస్ట్ ఆ లైవ్ వైర్ని డెడ్ వైర్ కింద చేయాలి. యూ ఆర్ నాట్ డన్ ఎనీథింగ్. సో డెఫినెట్లీ యు ఆర్ లయబుల్ ఫర్ కాంపెన్సేషన్ బికాస్ this type of incident should have been foreseen. Even though it is an accident, you do not expect it, but you have the idea, you must have the idea. So this is regarding the defenses in the so-called strict liability. Tomorrow we'll discuss the topic of absolute liability. Very good cases we'll discuss. Right. Till such time, bye bye. Thank you.